Suicide is the leading cause of death within jails. Our jails have become what they were never designed or staffed to be, America's de facto mental health institutions, because too many citizens with serious mental health issues end up there. Until the end, Jeffrey Epstein, a wealthy white financier with many powerful friends and clients, was a previously convicted sex offender who was facing a new indictment on sex trafficking charges when he died by suicide in the Federal Metropolitan Correctional Center in New York City. We will probably never know exactly why Epstein killed himself, but we shouldn't let what we don't know about his death distract us from what we do know. Suicides in jails happen with disturbing frequency, and for many, it's not a cynical ploy to avoid justice, but just the final act of an under-addressed mental health crisis exacerbated by inhumane conditions. Sandra Bland, a 28-year-old African-American woman, was driving to her new job in Texas in July of 2015 when a state trooper pulled her over for failing to signal for a lane change. Incredibly, the trooper transported Bland to the Waller County Jail. 3 days later, a jail officer found her hanging from a plastic garbage can liner tied to a post in her cell. She had not been seen by any jail staff for more than 90 minutes. Both cases led to a nationwide furor, and both cases point to a broader suicide problem. Who is responsible when an inmate dies by suicide? Suicide has been a lingering problem in detention facilities, and systemic factors such as inattention, understaffing, or inadequate training generally offer a simpler explanation for a prisoner's death than nefarious intent. Of course, many might ask, who cares? The answer has always been and continues to be, preserving life is our moral and legal responsibility. Inmates and detainees could easily be our daughters, our sisters, our loved ones, or our friends. Sandra Bland's death resulted in a significant reform of local jail suicide prevention practices in Texas. At a minimum, perhaps Jeffrey Epstein's death will result in renewed efforts to require an accounting of the number of people that die in jails nationwide. But suicide is so common in jail in part because too many citizens with serious mental health issues end up there. Increasingly, officers are called on to be the first and often the only responders to calls involving people experiencing a mental health crisis. In this insider-exclusive Justice in America Network TV special, America's Prison Suicide Epidemic, Hunter Lee Johnson's story, our news team is on location at Jackson Hole, Wyoming, with John Robinson, partner at Robinson Stelting Welsh Bramlett, and Brenda Johnson, Hunter Lee's mother, to go behind the headlines of the tragic death of Brenda's 19-year-old son, Hunter Lee Johnson, who died of suicide the day after Christmas, December 26, 2015, in the custody of the Laramie County, Wyoming Detention Center. His death was totally preventable. He had been arrested only on public intoxication and threatening to kill himself at a local Walmart only 5 days earlier. The jail staff had been put on notice of Hunter's psychiatric instability by his parents, who brought his prescription medicine to treat anxiety and depression to the jail. The staff placed him on a 15-minute suicide watch and kept him in a cell in the central booking area for closer supervision. But he was moved later that day. Johnson had repeatedly told the jail staff that he was having suicidal thoughts before his death, and they still left him unsupervised while he was detoxifying from alcohol addiction and coping with severe depression. At the same time, his 15-minute watch was discontinued. A 30-minute watch was implemented. Hunter's 30-minute watch was discontinued on December 21st, 2015. On December 22, 2015, Hunter was placed in the central booking area that had a live video feed in his cell. Here he is seen tying his shirt around his neck and trying to find a way to hang himself. He was later moved to another cell in segregation, and 35 minutes later, he successfully committed suicide despite the fact that the Laramie County, Wyoming Detention Center mental health staff knew he was an immediate risk to his own safety. Here's Hunter's mother, Brenda, to tell us about her son.
To tell you about Hunter, he was always very active as a little boy and always seemed like in trouble, mischief in school. The school was always calling and telling us, Hunter did this or Hunter did that. Started riding horses. That helped a little bit, keep him out of trouble. When I saw that Hunter was suffering these severe problems, I didn't realize how severe his addiction was until he came to me in February and told me. I had taken him to the hospital numerous times to try to get him help. As a parent who realizes that their child is suffering and you're unable to help your child, it's so devastating. I tried everything I could to help him. Hunter had been in jail and had went to court that day on the 22nd of December. I had went home after court and was outside when my phone rang, and it was the sheriff's office telling me that Hunter had been in an accident and I needed to get to the hospital right away. I remember pulling into the parking lot and my ex-husband was waiting for me, but they had given us the news initially that he probably wouldn't make it. And then come on Christmas Day, they wanted to shut off his life support. And I told them, no, you can't do it on Christmas. They pronounced him dead on the 26th, 2015. And that day forever changed my life. What I want to say to all law enforcement, listen, it doesn't matter if they have a plan. It doesn't matter if they tell you they're fine. My Hunter had bad news in court. He was visibly distraught and upset. He was suffering alcohol withdrawal. He was suffering depression. Listen to your gut. Know that they're not okay, whether they tell you they are or not. Keep an eye on them. Do not take them off a suicide watch.
In this special network TV investigation, John Robinson shares answers with the Insider exclusive news team and our viewers on important issues like, what does deliberate indifference to serious medical needs mean? And what kind of adequate health care is covered under the 8th Amendment? John Robinson has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Jackson Hole and across Wyoming. He is driven to fight for people who have been harmed by the willful or negligent actions of others. His goals, not only to get justice for his clients, but to make sure that everyone is treated with equal respect and dignity as guaranteed under the Constitution of the United States. He has built a substantial reputation by consistently winning cases other law firms have turned down. His amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Jackson Hole, Wyoming. It is my great pleasure to introduce John Robinson to the show. Welcome to the show, John.
Thank you, Steve.
Good to see you again.
Good to see you again.
Wonderful Wyoming, right?
Yeah. Welcome back.
Tell our audience a little bit about your firm. What do you primarily practice? What type of cases?
My practice is generally civil rights and plaintiffs' work for people who've been injured, wrongfully injured, either in accidents, but most of my practice involves civil rights cases, trying to hold government actors and government entities responsible for times that they violate people's civil rights and constitutional rights.
And oftentimes those rights are violated when people are incarcerated, correct?
Often, yes.
And today we are here to talk about one particular case, the Hunter Lee Johnson case. Tell our audience a little bit about the facts of the case. What happened? And by the way, who was Hunter Lee Johnson?
Hunter Lee Johnson was a troubled 18, 19, 20-year-old kid all through his late teens and into his early 20s. He struggled with depression, severe depression, They tried many medications. He unfortunately chose to self-medicate a lot with alcohol or other substances. He had attempted suicide at least once, and it was a really sad deal. And in fact, the week before he went to jail on a disturbance interference charge, where he was in a public intoxicated state at early morning hours. The week before that happened, he had threatened to commit suicide, and he was in a gym, basketball gym, at a game, high school game at his old high school in Burns, Wyoming. And when he left, he had said he was going to commit suicide, and they took him to, and they had him involuntarily committed, where he stayed until they determined he was safe and he could be released. So about a week later, he's at a Walmart, and he's intoxicated, and the police show up, and they ultimately take him to the ground, a pretty violent takedown, and they take him to the jail. And when they arrive at the jail, the officer who transported him told the intake people that he had made suicidal threats on the way to the jail, and they booked him in.
And his parents even came to the jail to bring his medication.
Yes, that morning, well, his parents were at the scene when he was arrested. Yeah. And early the next morning, they took his medications in that he needed for his depression and severe anxiety, and gave them to one of the nurses.
So everyone, including the jailers, knew that he had some mental issues.
Well, certainly should have known. I think there was a breakdown in the policies and the way that they handled communications at the Laramie County Detention Center.
What did they do initially? They put him on a 15-minute watch.
Right. They're on a 15-minute suicide watch.
And explain to our audience what that means.
What it means is they're in isolation, and they're supposed to be checked on at least every 15 minutes to make sure that they're okay, which might not be frequent enough when you're talking about a suicide risk.
It was later moved to a 30-minute watch, correct?
That's right. It was moved to a 30-minute watch. A day or two later, it was moved to a 30-minute watch, and then ultimately, after he'd been in for less than 48 hours, they took him off any kind of real serious suicide prevention watch.
Now, eventually, he was brought to court. He had an outburst in the courtroom. When he came back to jail, they put him in another cell, correct, with a video feed. And he was looking, it appears to everybody here, he was looking for some way to hang himself.
That's right.
Because he was intent on killing himself again. What happened after that?
A little bit. When he came out of the courtroom, he tried to leave the courtroom, and so the deputies had to take him down. And so when they took him back to the jail, they put him in this cell with a video feed because it was a booking cell. They were going to move him to disciplinary pod for having his outburst in court. And that was what initially got him so upset. So on the video, you can see him looking for different ways to try to commit suicide. After they took him out of that cell, they put him into the pod for the discipline, and that's ultimately where he committed suicide.
Which is very unfortunate. Now, when this case was brought to you, you've handled similar cases like this. What sort of legal challenges do you face in this state when you want to bring a case against the jailers who probably should have watched him more carefully, definitely, because he was very suicidal?
The legal challenges always start with qualified immunity.
And explain to our audience what that means.
So qualified immunity is a doctrine that was, it's a court-made doctrine, and essentially what it means is, and its initial intent was, if an actor, a defendant in a civil rights case, didn't have the ability to know that what he or she was doing was violating someone's constitutional rights based on other case law, then they're entitled to immunity even if they violate those rights. Unfortunately, over time, and I think it's going to continue to expand, this qualified immunity has almost become an absolute immunity because the courts now are interpreting it to mean unless you can find a case that has almost the exact same facts, then the officer or the government actor gets immunity and is not going to have to answer for what the constitutional violations that went wrong.
Right. When you initially filed the case, you filed it in federal court, correct? What happened?
We went through a series of depositions and discovery, and ultimately it went before the court on a motion for summary judgment by all the defendants. And the court granted the motion and ordered judgment in favor of the defendants.
Meaning that your case was dismissed?
Well, yes, it was dismissed.
Which theoretically, to a lot of people, would mean that's the end of the case. But then you refiled the case. How?
Well, while we had a two-track mode, while we took appeal to the 10th Circuit Court of Appeals on the federal case, we filed a state law case in Cheyenne in the state district court alleging negligence. So in Wyoming, you can file claims against governmental actors under certain parts of what's called the Wyoming Governmental Claims Act. And if the legislature has deemed certain things to be excluded from the regular immunity for the government, then you can bring a state action. We had filed what's called a governmental claims notice before we filed the federal case, so we were in time still to file in state court.
So there are provisions under state law where you can still hold, in this particular case, the law enforcement people responsible and accountable.
Yes, there's a specific section of the Wyoming Governmental Claims Act that provides for liability for peace officers.
And this case was eventually settled, correct?
It was.
Today we have with us Hunter's mother, who was very much involved with him, and we're going to bring her on right now. It is my great pleasure to introduce Brenda Johnson to the show. Welcome to the show, Brenda.
Thank you.
Tell our audience a little bit about your son, Hunter.
My son Hunter was very outgoing. He was ADHD, so he was very hyper, very impulsive in things he did. But he would do anything for anybody. He was just a great kid. He had a girlfriend that he treated like a queen. He would take her roses or flowers or donuts, and just a great kid.
Let's go back to that incident the last time he was arrested at Walmart.
His dad and I showed up at Walmart because we wanted to bring him home. Walmart had called the police on him because he was causing a disturbance. When the police arrived, we stepped in the background and he didn't see us. And the police went in. He immediately laid on the ground. They put handcuffs on him. His dad had already informed the police of how he could be combative. And it was two women, and he asked them to call for more help, and they wouldn't. And they started to bring Hunter outside, and he saw his dad and I, and he just turned over to being combative, and it was just a fight from the get-go. And they put the bodysuit on him and the headgear on him and put him in the car, and he was banging his head on the windows in the car, so they took him out and they called the ambulance, and they ended up strapping him in on a gurney to take him to the jail instead of to the hospital.
And we all know the story of what happened when he was in the jail, and we've discussed with John, you know, the legal implications and that sort of thing. What do you want to tell law enforcement everywhere about how to treat people who have mental issues when they're arrested?
For one, to have some compassion and think that, you know, that might be your child one day. You never know. And for two, I would like them to know that we all have a history, and that history needs to be, when they put Hunter's name in the computer, when they went to put him in the system, to me it should have been red flag that he had been in and out of the hospital numerous times for suicidal ideations, and that they need to pay attention to that. Just because he tells them he's fine doesn't mean he's fine.
As John and I have talked already, you know, because jails have become the de facto mental institutions today, law enforcement needs to be trained, just as you've said, to be able to look for these issues, deal with the issues, etc. What do you think about the way your lawyer, John Robinson, handled the case?
I couldn't have asked for somebody that was more compassionate and caring, and just, you know, he always had my best interest at heart and Hunter's best interest at heart, and, you know, encouraged us and did the best that we could to get Hunter's story out there and to share it. And I just think the world of John.
I want to thank you for being on the show.
Thank you.
John, let's talk about preventing suicides in jails, because it is a serious problem. We see a lot of cases across the country, including Jeffrey Epstein, right? Oftentimes, jailers are, let's say, they don't have the training, And jails have become the de facto mental institutions, haven't they?
Yes, they have.
I read someplace that maybe 1/3, maybe, or 40% of the people who are locked up right now have some sort of mental problems and addictions, either to alcohol or drugs. How can that be changed?
Well, we need to have a better training situation for the officers who work as jailers. They need to be better trained on how to look for suicidal signs. There needs to be better policies concerning communication between healthcare, mental health care, jailers. In the case of Mr. Johnson, his earlier involuntary commitment from a week earlier was actually in the possession of the county attorney, and they had a policy not to share that information with the jail itself. So the jail, they completely shielded the fact that they knew he was a suicidal risk, even though it was in the county attorney's possession.
What kind of policy is that? I mean, that should be a policy that the law enforcement needs.
It's a policy to fail, is what it is.
So let me ask you, these are difficult cases, and not too many lawyers take them on. And I've seen you've handled quite a few of them, especially with, people who don't have reasonable medical care, in jails and that sort of thing. Why do you take on these difficult cases?
Well, I feel like it's my job. It's what I'm paying back. I don't think there are enough lawyers who do these cases. I find it very satisfying to look out for the little guy, to try to hold government accountable when they violate people's civil rights, constitutional rights. And there is a sense of at least having some impact on or making change to make society a better place.
What does society owe our incarcerated?
Well, when it comes to health care and just the conditions of confinement, they owe them humane conditions, adequate health care, adequate medical care for their serious medical needs.
Now, since jails have become basically mental institutions, what's to be done about that? I mean, there used to be a lot of mental institutions, but there was a lot of abuse. And I think that's probably the reason they got closed. Now you have the same thing going on in jails. What is your suggestion for a solution for this?
Well, I think it's better training. It has to be better policies, across-the-board policies that are adopted maybe on a statewide level, if not a federal level, to require minimum levels of humane confinement, humane conditions of confinement, adequate health care.
Two last questions. What's your opinion of the legal system in dealing with these types of cases?
Well, the legal system is actually set up well to deal with these types of cases, especially because of the Civil Rights Act and the different governmental claims acts that exist. The problem is the courts have sort of eviscerated that with disqualified immunity.
How have these cases changed your life?
It certainly gave me inspiration to do what I do. I don't know that I would still be a lawyer today if I hadn't figured out this area of the law. It's very meaningful.
I want to thank you for being on the show.
Thanks, Steve.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.